All right, Scott. Guys, before I call the docket, I'm going to take up this case with this person because they have to be at school. All right, Joshua, how are you doing?
Hi, ma'am. I'm doing good. Thank you.
All right, and thank you so much for look at you. You're a student and you're dressing appropriately for court. I appreciate
Thank,
that.
thank you so much.
All right, so how's everything going with you?
It's been going good so far. Thanks, ma'am.
All right, see, you can't end that with the so far thing because when you end it with the so far, that's inviting negativity. So everything is going good, period.
Yes, everything is going fine.
All right, so is there anything that you need from me? Any concerns? Now's the time to voice them.
First of all, I was gonna say that I joined the culinary club. I joined the club that you asked for. It's
Yes.
called Culinary Club. We cook in there and I like it. I'm having fun.
All right.
And
What's your favorite dish?
excuse me,
What is your favorite dish that you all have had to make?
it was a it was a type of a coffee we did last week. I don't remember the name, but it was good.
We used to have it in my school, but we called it home economics back in the day. And they would make you make a cake and candy apples and stuff like that.
Oh,
Well, I'm
yeah,
glad you,
thanks.
yeah. Well, I'm glad you've joined the club. It's always good to join different clubs. One, it helps you when you're trying to get in college because now they really want to see extracurricular activities and other things that you've been doing. And also, it's a good chance for you to get a chance to discover where your passions lie.
Yeah,
Okay.
yes,
So,
man.
any issues with GPS for you?
No, not right now. I
Okay, see, he's in it with the not right now.
I think he has to qualify everything.
So, you haven't had any violations for GPS?
no, man.
Okay. All right. So this is what I'm going to do because how long have you been on GPS?
For about 7 months.
All right. So I gave you leeway by giving you partial GPS. So this is what I'm going to do. I'm going to remove the partial. We're going to do tracking for 1 month. If there are no issues with GPS on tracking for 1 month, I'll strongly consider removing it at that time. So you can't have any violations for 1 month. You understand?
Yes, ma'am.
I don't know if he knows what tracking only means. I can
All right.
tell him, but
So this is what tracking means. Tracking means that you're not going to have to report in and let people know I'm going here or I'm going there. Any conditions where I told you you can't go someplace, those still are remain in effect, but you won't have to call somebody up and say, hey, I know I'm partial for school and church activities and work, but I want to go to the park. You won't have to call them for that. You understand?
Yes, ma'am.
So whether or not GPS is removed is 100% in your control. If you violate it, it's not going to be removed and it may go back to the way it was before. You understand?
Yes, ma'am.
So I'm going to depend on your attorney to have you zoom back in 1 month. And then if there are no issues, then GPS will most likely be removed.
very good. Thank you, Judge.
All right. Is there anything else you need from me?
No, well, just that. Thank you, ma'am.
All right. You're welcome. Have a great day at school.
You too. Thank you so much.
All right. Bye-bye.
Thank you,
Bye.
Judge.
Bye. All right. Vashon.
Yes, Judge.
On Wong, I'm going to remove the GPS partial condition to tracking only. So everyone, these are the rules, and I need you all, attorneys especially, to follow these rules. When I am on the record, do not approach the clerk, do not approach the deputies, because your fellow colleagues are making arguments to me. I want to give them 100% of my attention, and I can't do that when people are over here talking. And to the staff, when people come up to you and we're on the docket, do not talk to them because we're on the docket. So there's a sign on that computer that says, do not approach while we're on the docket. And if we follow these rules, guess what? You will be in and out of here quickly. I can't tell you the number of times where I have to tell people, please lower your voices. I can't hear. The court reporter can't hear. When we are on the record, do not speak behind the court reporter. If you have someone who's in the box, all you have to do is ask the deputy to move you to the other end, they will. Of course, if there are already attorneys talking to inmates on the other end, You'll just have to wait your turn. Do not approach the court unless you have talked to your client and talked to the state. And if your client is in custody, yes, they need to be brought out. If your client wishes to speak to the court in a language other than English, yes, we will need an interpreter. Even if it's for a reset, we will need an interpreter. Do not approach the coordinator asking, can I get a reset? Can I get another date? I'm the only person who can give you a reset. Nobody else has the authority to give you a reset. Today is Monday. It's going to be a great day if we follow the rules. Over here, we have the probation officer. Could you raise your hand, Vashon? Attorneys. If you have somebody who's on probation, or if you're seeking to have somebody receive probation, talk to the probation officer. She's just not here as a piece of furniture. She has valuable input. And guess what? You're going to slow everything down. And the reason why you're going to slow everything down, because guess what? I'm going to ask at the end of the day, probation, how do you feel about that? And if you have already talked to her, we can cut that out of the time constraints. So the deputies, once you requested your inmate, do not leave. For security reasons, there's a limited number of inmates that can be in the box. So once you requested it, don't leave. Do not leave if you've asked for an interpreter, because there's a limited number of interpreters. And unless they're in a jury trial, they can only be here like 2 or 3 minutes. To the people in the audience, number one, do not talk to the inmates. If you want to have a visit with them, you need to have a visit with them at the jail, however they're doing it. And my understanding is they only do it by video. If you talk to the inmate, you're going to be asked to leave, and don't act all shocked, because I'm telling you, you are not allowed to talk to the inmates for security reasons. Do not take photographs of the inmates. If you want a photograph of the inmate, back in our day, it was Olin Mills. You need to wait till you can bond them out and set up some kind of photo shoot with Olin Mills, or however they're doing it now. If you talk to the inmates, if you take photos of the inmates, guess what? You're going to be asked to leave. And the only way you will be back in this courtroom if you are subpoenaed as a witness. So today is Monday. It's going to be a glorious day, even though it's supposed to be, I think, fall, and it's going to be 92 degrees today. We're going to have a great day. It's a new beginning. So everyone, please confer, and attorneys, confer with a smile on your face and kindness in your heart. All right, everyone, please confer.
Dr. Rodriguez?
John Ramirez? Hello, good morning. So what is the update on this?
Yes, Judge, since last time, we do have some new developments. He is currently getting Social Security now for his mental health issues, so he's going to have an additional stream of revenue. And I know the Community Supervision Office was helping with that, so very much kudos to them on that, Judge. He's taking his meds as required, and he's stabilized on that. I've noticed a significant change in the first time he was brought up here on this compliance issue. He, I think, believed that the only thing at this point that he's having hiccups with are the UA, because he had lacked funds before and he was having issues monetarily paying those off. But I believe in the status report, he had been tested twice before. As of recent, they were negative, and I think he had 3 missed tests. So Vashon has strongly admonished him that he needs to make those tests. So next time we come before the court, he checks up all the boxes, there's no issues, and it shows that he's being serious about this probation, Judge. I think that the probation office was recommending the dual diagnosis outpatient program, which my client is definitely looking forward to doing to get help with his issues, Judge. And I think that's the extent of where we're at.
All right, so are you going to have any further problems with paying for UAs?
Yes, ma'am.
I'm sorry. Are you going to have any further problems with paying for UAs?
No,
Okay.
very happy because I went for years.
SSI, yeah.
For security. Okay, now I'll be accepted.
All right, awesome. Probation, anything else?
No, Judge, we would request amending conditions for the dual diagnosis outpatient program and bringing Mr. Ramirez back in 90 days for a status update.
All right, so that's what we'll do then.
Okay.
But let's bring him back in 60 days. I think 90 days is a little bit too long.
Okay.
So we're going to bring you back in 60 days to make sure that everything is going as it should be going. if you need something and you need to come back earlier to address anything with me,
Yeah.
then you can always come back earlier.
Okay.
Just let your attorney know.
Yeah, thank you, ma'am.
All right. I need a 60-day reset. All right, it's slightly less than 60 days, but you want to put this on December 12th?
Your Honor, if I may,
Yes.
I'm gonna be out as of December 11th on vacation. Could we do a little bit maybe before December 11th?
We can put it on December 9th.
Perfect. Yes, Your Honor. Thank
All
you.
right, so we'll come back on December 9th.
Appreciate that, Your Honor.
Thank you, ma'am.
All right, thank you. Once you sign the reset form, you're excused. And thank you for dressing appropriately for court. I appreciate that. Oh, hey, I like that. Oh,
I
okay.
made it myself.
Okay, it's beautiful. And I tell you what, if you miss your appointments with that, then you just don't want to be for your appointment.
Okay.
All right, who's here on Marco Antonio Marino? All right, so I see that you all have the order for disclosure for the CPS records. What I can tell you all is normally a copy is not given to expert witnesses or investigators. It's usually just a copy is given to the defense, and the defense has certain obligations with protected information. I don't feel comfortable saying this is protected information and I'm giving it to the expert witness, I'm giving it to experts and investigators. So counsel, normally what would end up happening is you're in charge of the protected information and you've got to make sure it's protected.
Sure.
So any objections to the court removing that?
No objection.
Okay. Okay, let's go off just one moment. That you all are waiting CPS records. Does the state have those CPS records in their possession?
I see that they do on a disc. Yes.
All right, so is there anything other than the CPS records that's outstanding?
Not that I know of. I recently got a report of a DNA analysis
Okay,
and that was dated September 18. So I am not sure if there is anything more to come. I did file some pre-trial motions that I could approach you with
Okay.
off docket. They are awaiting acceptance.
okay. Are any of those motions you want to approach me on, are they ex parte motions or no?
Not at this time, but those are forthcoming.
All right, so this is what we're gonna do. I'm gonna set this for motions so that we can make sure that this is moved. So Norma, on this case, can you set this for motions on November, the week of November 18th? All right, so we'll come back on November 18th. That's when I'll hear your motions. And of
Perfect.
course, if it's something that's ex parte, we can go in chambers and speak about it.
Got it.
All right, is there anything else?
Nothing further.
All right, Mr. Marino, do you have any questions? All right, so you're gonna come back on the 18th. The 18th is not your jury trial. It's for your attorney to have heard what motions that may need to be heard. And if you'll confer with the state to see if there's something that you all can agree on.
Sure.
And state on November 18th, you'll need to be prepared to tender an offer.
Yes, sir.
All right, is there anything else?
No.
All right, thank you.
Nothing further.
So they'll send you back if you're done with speaking with your client. If not, you can continue to speak with him and then we'll get the CPS records for you.
All right.
All right, thank you.
Thank you. We'll have a seat, sir.
Who's here on Stephen Tennyson? All right, if you'll come forward. And where's your client? All right, Mr. Tennyson, come down. Yes.
This is, he has a trafficking case as well.
Ah,
So there's two different attorneys for his cases.
okay, so has the trafficking case, has that been indicted or no?
It has.
All right, could I see the file on the trafficking, please? So that we can make sure that both of these are set. And who is the attorney on the trafficking case?
Scott Sullivan, Judge, I just got off the phone with him, and he's sort of driving the bus because I've got this unauthorized use case and,
Okay,
he says he didn't know it was set. It wasn't on the Odyssey. So I'm kind of stuck up here. I have conferred on my little case compared to the big one.
okay. Well, no case is little. They're all big cases.
That's true, Judge.
Yeah.
He says he's not gonna get here till 11.
All right, well, I will tell you, you can be excused.
Oh, thank you.
I'm gonna note that you were here So if there's any issue, it'll show that you were here, and we'll wait for the attorney on the other case. And what I'll do is these cases will continue to be set together on the same day.
Right.
All right, so I'll check that you were here.
Well, thank you, Judge.
All right, you're welcome. Have a good one.
See you next time. Sir.
Thank you. All right, so Mr. Tennyson, if you have a seat, your other attorney will be here at 11. And that case is a higher degree felony than this case, okay? All right, so just have a seat.
He said maybe 10:30.
All right, well, maybe 10:30. We'll see what happens.
Thank you, Judge.
All right, thank you. Freddie Garardo? Who's here for Freddie Garardo? All right, so thank you for dressing appropriately for court. So today is plea deadline date. So have you all reached an agreement or you're all requesting jury trial?
Well, Judge, there's new prosecutors in the court. There was an offer made to me by the previous prosecutors. We made a counter, but they're not familiar with the file. So there is no agreement. It's just whether you want to give them time to consider it based on my reasons for the counter offer, or whether you just want to give us a trial setting. It's up to the court.
All right, I'll give you all till Thursday. Will you be able to make an offer by then or no? Or consider his counter offer? I'm sorry, what? All right, I need a jury trial date. How long do y'all expect this to last?
4 days, I would expect.
4 days? All right, you always overestimate to
Well-
give some cushion in there.
Well, I don't want to underestimate. I mean, it could be done in 3.
All right, I need a 3-day jury trial date for family violence. All right, so we're gonna be back on November 4th for jury trial. And counsel, that'll be your plea deadline date and jury trial date to give them a chance to see if they'll consider your counter offer.
Judge.
All right, any other questions?
No, ma'am.
All right, once you sign the reset form, you are excused.
Thank you.
You're welcome. And counsel, can you make sure that you've done an acknowledgement of discovery as well?
Yes,
I
ma'am.
think there may be one done, but obviously doesn't show me. All right, so who is here on Elisa Herrera? All right, did you do a trial court certification?
No.
All right, so you need to do a trial court certification. They're right over there. All right, and once you all do that, I'll take you up. All right, court is calling 2022 CR 10343, State of Texas versus Elisa Marie Herrera. Can I have parties announced for the record for the state? Defense.
Ms. Herrera?
And Mr. Wolf, you're on this side for security purposes. And are you Ms. Herrera?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did
Yes,
you
ma'am.
understand it? Are you the same Elisa Marie Herrera who's placed on community supervision in 2022 CR 10343 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on December 20th, 2022 for a term of 8 years? Is that you?
Yes, ma'am.
How do you plead to that? True or not true?
True.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 8 years in the prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court is going to find violation of condition number 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is for safety followed by aggregate.
And that's our understanding, Judge.
All right,
We're in
why-
agreement.
Why should I follow that? Because hasn't she been to felony drug court?
Felony drug court has a lot of requirements and very onerous.
Yes.
She was doing well there. She had completed safety. Just had a relapse. It happens. I know Judge Glenn understands that. The thing that triggered all this really is the fact she took her monitor off, which is another allegation. But just so that she was staying at home. She was arrested at home. It was just so burdensome that so now she's facing coming back here and looking at being, if you do follow the recommendation of the probation office, being locked up.
I will tell you, I'm not going to continue her unless somebody from felony drug court wants to zoom in and says, we think this would be best because felony drug court, yes, it's a stringent program. They're trying to get you to be clean and sober. And if you're not following their rules, then there's nothing I can do for you because at the end of the day, I can't monitor you as closely as they can monitor you. So prison may be the best thing for you. You had choices to make and you made choices. Felony drug court does not remove someone from the program based on the fact that they had a relapse. They understand that sometimes in people's lives, relapses occur. But this other thing that your attorney is mentioning about the removal of the GPS, yeah, you probably shouldn't be on probation. You should probably go to prison.
Well, she is, she's been sitting in jail now for about 50 days. She understands her circumstances. I've explained to her what a trip to TDC would do going forward to her record. She is committed to making a success of her probation, and she's asking for that opportunity.
Well, I'm going to revoke her. Do y'all want to speak to time? The court could sentence her up to 8 years.
I'd like to get her how much credit she has, Tony. 165 days.
I mean, if she successfully completed inpatient treatment, I'll give her credit for successfully completing inpatient treatment. But if she didn't successfully complete it, then
She did
she's not getting
successfully
credit.
complete it. It's in the probation report.
Okay. Any objections to the court reviewing the probation report? Yes. So I'm reading the court summary, and in the court summary, it says that you tested positive for cocaine, you admitted to using, and so they tightened your sanctions. And then you didn't call the UA hotline. One time you called late, and then you failed to submit, and then you had another positive, and they gave you sanctions instead of removing her from the program. So they understand that, but when you're not trying at all, there's nothing they can do, and you were not trying. So, all right, so I'm going to revoke, sentence you to 6 years in the prison, give you credit for any time served, and credit for any time served for successful completion of inpatient treatment. There's $1,000 fine. Time and money will run concurrent. All right, was the restitution paid to the Bexar County Crime Lab for UAs? For testing of the drugs? Did you pay $57 to?
No, good.
All right, so there's to be restitution of $57 to the Bexar County Crime Lab for drug testing. Or I should say for the testing of drugs. And counsel, what I'll do is I'll recommend the therapeutic community.
Thank you.
You'll have to ask for it as well because I have no jurisdiction to force you to have them forced to take you into the program. It doesn't increase the length of time that you are in the prison, but at least it will give you hopefully some tools so you will not be back here for drug use. You understand?
Yes, ma'am.
We can go off the record. When you're released from prison, if you don't know where to go, if you don't have a place to stay, if you don't know where to get treatment, if I'm here, you can still come back here and I will guide you and pick up the phone and call people who can help you maintain your sobriety.
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Angus Talbot. Okay, so we're here for discovery. Where are we on that?
I've received preliminary discovery. I'm still reviewing it, so I don't know whether that's that we're in a position to move forward from discovery, exchange and review. So I'm hopeful that you'll give me another discovery setting. It's pretty voluminous.
All right, so let me see. And State, do you believe you've uploaded all of the discovery?
I believe so, Judge. This is sort of a new co-defendant case, but we believe that everything's uploaded, but as I told Commissioner Plum, I'll make sure.
All right, let me look at my calendar. Just give me a second.
And if it helps you in evaluating this, I talked to Mr. DeWalt on the co-defendant, and he's pretty much in the same positions.
All right, we're gonna recall this for November 21st. By then, you all should be able to tell me where you're on discovery. What's gonna happen? I expect that to be the final discovery date. And then the next setting, the state is gonna tender you an offer, and then there's gonna be a plea deadline date.
Very good.
All right,
Thank you.
so November 21st.
Thank you, Judge.
All right, do you still need to speak with your client?
No, Judge.
All right, Deputy Laura, they're finished with Mr. Cabot.
Mr. Enrique Hernandez, Judge.
Enrique Hernandez? I don't know if the interpreter needs information from you, Leo.
I already give it to him. Deferred, Your Honor.
Thank you, Judge.
Sure. Okay, so first things first. I have a motion for substitution of counsel.
Correct. I'm only filling in for Mr. John Sanheinrich today. He's unavailable. He's in a different county today.
Okay, so has he? Is he with your firm?
Correct.
All right, so we'll go on the record. Court is calling 2024 CR 007-306 State versus Enrique Hernandez. Can I have parties announced for the record for the state?
Daniel Escobar, State Executive.
Leo Gonzalez for Enrique Hernandez.
And are you Mr. Hernandez?
Yes.
All right, if I could have the interpreter, if you could raise your right hand for me, please. Do you solemnly swear and affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Mariana Rios.
All right, so the first thing in this case, there's a motion to substitute. In defense, you tell me the attorney who wishes to substitute is John Sanheinrich.
Correct.
And for the court reporter, that's Sandheinrich. And is that attorney with your firm?
He is here with our firm, Dunham & Jones, Your Honor.
Right. All right, Mr. Hernandez, do you have any objection to this attorney standing in for that attorney?
No.
All right, so I'll sign the order of substitution. And now the next issue is, he was here on August. And my understanding, he needed an immigration attorney. Has that been taken care of, counsel?
I'm not aware if that's been taken care of. I know there's been discussions of that. The other issue, Judge, is that Mr. Sanheinrich is attempting to get his email set up to receive the discovery on this case, so he can review it with the client regarding any offers that are made, and then use that information to go over it with the prospective immigration attorney.
All right, and can you tell me, you all are, is he appointed or not appointed?
He is not appointed. We're retained on that.
All right, so you all will be taking care of the matter of immigration attorney?
Yes. Reaching out and discussing that.
All right, so what I'm gonna do, because I realize this case is fairly new, we've only had one prior setting. And my understanding, the blood discovery order had been signed. So I'm gonna set this for final discovery date. And that final discovery date is going to be on November 19th. Is there anything else?
No, Your Honor.
All right, once he signs the reset form, he's excused.
Thank you, Your Honor.
All right. They'll get you the reset form, then you're excused. Thank you. Yes.
Thank you, Judge.
Hi. How are you doing?
Great. Doing fantastic. Thank you.
Awesome. Have a good one.
Thank you too.
All right, the party's on John Martinez. We're gonna go on the record. Court is calling NIGHT-MAG number 707619, State of Texas versus John Anthony Martinez. Can I have parties announced for the record for the state,
Daniel Escobar, State of Texas.
for the defense?
Leo Gonzalez for John Martinez.
And are you Mr. Martinez?
Yes, Your Honor.
All right, so the court is in receipt of a motion to substitute counsel, and this attorney is asking to be substituted in as your attorney. Is that correct?
That is correct, Your Honor.
All right, do you have any objections to this attorney being substituted in as your attorney? All right, so that will be granted. Now, the next issue we have is the court is in receipt of a violation report. You had a first violation report, and the court ruled upon that. You were to continue with no alcohol use. And the ignition interlock order was to be within 15 days calibrated. So now the court is in receipt of a second violation report. Have both parties had a chance to review the violation report?
Yes, Your Honor.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
And according to the violation report, there's a high BRAC reading. So who wants to address this issue with the court?
I'll let Mr. Martinez explain to the court what the situation is, Your Honor.
All right, I'm hoping your explanation is not going to be NyQuil or anything of that nature. All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
John Martinez.
All right, make sure you keep your voice up so that I can hear and court reporter can hear. Yes, what would you like to say?
Yeah, Your Honor, I know it's my first and like screw up. It could be my last, but I did have a couple drinks with my dad.
I'm sorry, what?
I did have a couple drinks with my dad tonight. I know I'm not supposed to, but I do soldier and I'm hardly like around my family, I hardly see my family, so I just went to go be with them, spend time with them, catch up with them for a little bit.
So does your father love you?
Yes.
Do you think he loves you? Then why would he have you drinking around him? Does he not know you have a DWI?
He
pending?
knows it does. He did not make me. I make the choice too. Like I said, it was my first screw up, and it will be my last.
Let's not use the term screw up. I think screw, that term just sounds so horrible. So you made a bad choice. You drank, you're not supposed to drink. That's a problem for the court. I appreciate you being honest about it, but that's a problem for the court.
Yes.
So state, what are you requesting?
Judge, based off of that, I was confident to ask the full house arrest instead.
Judge, he does indicate, as he just told you, he has a job, a good paying job doing solar installation. So in the alternative, we'd ask definitely to prevent any issues going forward, possibly the scram to be considered. The full house arrest, though, would be a concern to his livelihood at this point with the job that he has. This didn't occur during a job site, but maybe weekly meetings with pretrial to make sure that he's no longer using, I think would be a better use of the resources to allow him to continue to work.
Well, see, here's my thing. Why are people never thinking about this? About I have employment, I have family, I have children, I have all of these obligations when they are committing an act that they know they are not allowed to commit. Why is it just now? Oh my gosh, I have a job.
I'm sorry, Your Honor. I'm on top of
You can
my
unfold
stuff.
your hands. Yes.
I'm on top of my stuff. I've been doing my calibration tests on time.
But no, you were not on top of your stuff on this day.
Yeah, I'm sorry about that.
How often are you drinking alcohol?
Not often.
What does that mean?
Not very often.
No, what does that mean? I'm not with you, so I don't know how often you're drinking or not. If I were in your house with you, I would be able to say, oh, Mr. Martinez drinks on this day and this day and this day. So how often are you drinking alcohol?
Very rarely.
What does that mean? I'm not with you.
Like,
When's the last time you had a drink?
To be honest, the last time, just this past Saturday. That's it.
This-
I didn't drive nowhere, didn't do nothing, just stayed home.
All right, so this past Saturday. So let me just tell you, counsel. Your client know that he's looking at potentially me removing his bond and placing him at the Bexar County Jail, but he continues to drink. So obviously he has an alcohol problem. So the question is, how do we address that? I know he has employment and nobody wants him to lose his employment, but we have issues. So this is what I want you all to do. Maybe there is a sober house for him, maybe where they'll allow him to work. So let's think along those lines. Figure out a solution where he can keep his employment, but we address this issue so the public is not in danger. I know technically the public, if he's drinking, his car is not going to start, but let's figure out how to address that issue. So if y'all want to confer, because obviously he has a drug and alcohol issue, obviously being on bond is not enough to stop the use of alcohol. So we need to come up with a solution, what we can do to protect the community, plus make sure that he is not perhaps driving somebody else's car without an ignition unlock. But so far, it appears that he's been abiding by the rules of blowing into the ignition interlock, even knowing that it's going to be positive. So let's try to figure out a way to protect the community, but get him the help. I'll note that this is the first violation report that's for a high BRAC reading. The other one had to do with the calibration, and sometimes the machines are not working.
Yes.
So we know that this was a true positive. So you guys put your heads together, see maybe if lifetime recovery will let him be there, but allow him to work because he needs treatment. All right. And so then we'll come back and figure it out. And thank you for being honest. Jacob Kawazoe. All right, so Deputy, I realize that on this case, because they're co-defendants, it makes for difficulties in transportation. So the other person was set for a final discovery on November 21st. So I'm going to put you on November 19th. That way it won't be a short time to, a long time bringing him up because they have to keep them separated. So November 19th will be your final date for discovery.
Yes, Your Honor.
All right, any other questions?
One other, Your Honor.
Yes.
I had put in a motion for an appointment of an investigator. Can I hand it to you for it to be
Let me
considered?
see. All right, that is done. And you can take a photo of it. All right.
May we be excused, Your Honor?
Hmm?
May we be excused?
Yes,
Thank you very much for your consideration.
you're welcome. All right, are you all ready to approach?
Yes, I'm Mr. Tennyson.
Yeah,
And
Mr. Tennyson? If you'll come down. All right, on this case, where are we on discovery?
Your Honor, I believe defense has a motion that he'd like to urge, but just to keep the court informed, we do still have some outstanding discovery, one being the juvenile victims CPS records. Those have been requested and we're just waiting for the department to comply with that request.
All right, and how long do you anticipate that taking?
Your Honor, my address support with respect to a conflict.
Yes.
I filed a motion this morning. I didn't know this, we were set today. I looked at my docket sheet.
Mhm.
I didn't see it. I may have miscalendared it, and that would be my fault.
Okay.
So I apologize for it. Got a call, got here as fast as I can. In the past week, in reviewing some things and making some determinations, I have a severe conflict in this case.
Okay.
Obviously, it's of the confidential nature. So I filed the motion and I have the order today at the court warrants.
All right, let me see the motion and I'll read it.
The order's attached.
All right, thank you. All right, so let's do this. All right, court is calling 2024 CR 007876, State of Texas versus Stephen Jerome Tennyson. Can I have parties announced for the record for the state?
Megan Galloway.
For defense.
Scott Sullivan, present and ready on my motion.
All right, and are you Mr. Tennyson?
Stephen
I'm
Tennyson.
sorry, yes, is that you?
Yes, ma'am.
All right, your attorney has filed a motion to withdraw. He states that he has a conflict on several different grounds. Do you have any objection to his withdrawing?
I know.
All right, you're excused. Fine.
Thank you, Your Honor.
All right, so what we're going to do is there will be an attorney appointed to represent you, and I'm going to appoint Monica Guerrero and also Michael DeLeon. So those will be the two attorneys who will be representing you.
Thank you.
Counsel, we can go off the record. My understanding from the state is there's some outstanding discovery. One of the outstanding discovery is CPS records, but they requested them. And where we left off was, what time frame do you think those will be available?
Judge, I would expect in about 30 days.
Okay. All right, so what we're going to do, and Mr. Tennyson, we're going to recall this, and we're going to recall it for November 19th. And that will just be a discovery to make sure that these two attorneys have the information they need. Once they're put in the system, then they'll have access to all of the discovery. Right now, because they're not in the system, they don't have access to the discovery, okay? All right, so they'll speak with you in the box for as long as you need to speak to them. All right, so we'll come back on November 19th.
Thank you, Judge.
All right, thank you.
Have a seat, sir.
Renee Camarillo. All right, today is plea deadline date.
Yes, Judge, I think we are ready to, we do not want to take a plea. We want to go to trial.
All right, so you're requesting a jury trial? All right, State, how long do you expect this trial to last?
24 hours.
3 to 4 days? All right, it's criminal trial division, 3 to 4 days.
I expect it to be a little bit longer than that, Judge.
I don't. All right, December 10th. All right, what will end up happening if you'll be brought over dressed for trial, and whatever civilian clothing you have at the jail, if you wish to be attired in something differently, you'll need to do a clothing exchange. So you'll need to sign that form, and then your attorney or someone else at your attorney's request will do a clothing exchange. If you don't sign that form, you're going to be brought over in whatever clothing you have at the jail. You understand? All right. And have you all signed a acknowledgement of discovery?
No, Judge.
All right. Once you sign that, then you are excused.
Judge, may I hand you some motion?
Yes.
Thank you.
Okay, I thought I had already signed this because this is on the 15th. Check with the,
One is July, the other one is newer. I think
all right, check with the clerks to see if it's already been
Okay.
signed. Because
Thank-
usually if those come across my desk, I sign them.
thank you, Judge.
All right, you're welcome. The person who's on Perez, is that the person who needs the interpreter?
Yeah.
All right.
I didn't sign it.
Morning, Your
Good morning.
Honor.
All right, court is calling. Oh, guys, if y'all can move to that end. Deputy Laura, can you have Monica and her client move to that end? All right, court is calling 2024 CR 3071 and 2024 CR 3072. State versus Miguel Perez Naranjo. Can I have parties announced for the record for the state? Defense?
Jesus Darza for defense, ANDARCA.
And are you Mr. Miguel Perez Naranjo?
Yes.
So you entered a plea of guilty in each one of these cause numbers. In each cause number, you applied for deferred adjudication. And another judge took this plea because I see in the plea bargain agreement, it doesn't state whether the state is in agreement with the application or whether they are opposed or silent.
Yeah,
Says that we recommend deferred.
yes.
Okay, so the state
Yeah.
is recommending.
Yes,
yeah.
I was kidding. I don't know why.
Yeah, I figured that out. There you go.
All right, according to the plea bargain agreement in each case, the state is recommending deferred adjudication. There's a $1,500 fine. The cases are to run concurrently. They're taking in consideration 2024 CR 3070. And there are several individual complainants and also Walmart. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
Any objections to the PSI report?
No, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, off the record for a moment.
Yes.
It's tap only. Okay, we're back on the record.
That's
All right,
what-
thank you.
Yeah.
Mr. Perez Naranjo, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand, state your name for the record.
Miguel Ángel Pérez Naranjo.
Okay. Do you have any children?
Sí. Yes.
What are their ages?
7 y 3. 7 and 7 and 3.
And are you here legally?
Legally.
So this is what unless either party has some other information for the court will make a ruling on the application. All right, state you may be excused. And cause number 2024 CR 3071. Court will sentence you to 8 years. Deferred education. Employment. What do you do?
Mechanic.
Okay, that I understood. All right. There's to be 150 hours of community service restitution. Once he completes parenting classes, that will be deemed satisfied. Regular reporting by Zoom or in person. I'm going to follow the TAP evaluation. There's to be regular UAs. There is to be proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 3 months. This will run concurrent with 2024 CR 3072. There's a $1,500 fine that will be probated. There's to be no contact with and restitution to the following. Vashon, are you ready?
Yes.
Walmart, Katie, Kite, Fuentes with an S, Monica De La Rosa, and I know my accent is off sometimes, so that's DeLorosa. Alvaro Maldonado, Robert Kalik, Kalik, Andrew Bain Bridge, Hector Loriano, Monica Maldonado, Jacqueline Ali, Amy with a Y, Beck, Brett, Brett Brown, Andrew Bergensen, Bergesen, Alan Barajas, Tyler Canada, Jeffrey Schoenberger, Schauberger, Luis Hernandez Chavez, Joseph Williams III, Stephen with a V, Benavides with an S. Probation, is there, and then probation, I'm gonna add cats 1 and 2 for theft. Probation, is there anything else he needs?
No, Judge, I do, if you don't mind, Andrew, can you give me Andrew's last name again?
It's Bainbridge, Bainbridge.
Thank you.
And State,
Yes, Judge.
do you have a copy of the plea bargain page so you can give that to Miss Abrams so she'll have everyone's spelling?
Yes, Judge. I can do this.
And we're going to take in consideration 2024 CR 3070. And Ms. Ferguson, on this case, I need a 60-day reset for restitution hearing. And state at that time, you need to be prepared to present a restitution amount if there is one.
December 5th.
So we'll come back on December 5th for a restitution hearing.
See. Yes.
Next, we're moving on to cause number 2024 CR 3072. Court will sentence you to 8 years deferred adjudication, 150 hours of community service restitution. I'm going to order CATS 1 and CATS 2. Once that's completed, the community service hours will be deemed satisfied. Regular reporting by Zoom and in person. Regular UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits. 1 time per month for 3 months. This is to run concurrent with 2024 CR 3071. There's a $1,500 fine that will be probated. Take in consideration 2024 CR 3070, and there's to be a restitution hearing on 12/5/24. Probation, is there anything else needed in that case? All right, we can go off the record. And this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes.
And in each of these cases, if there is restitution to be paid, I'm going to expect that it is paid. Do you understand?
Yes.
All right, thank you. Just have a seat and probation will go over conditions.